Item number 1, pronouncement of judgment.
Yes. A contextual interpretation of the term court as given the Act will involve analyzing the facts of the case, legislative intent, to understand its purpose and application, whereas textual interpretation, on the other hand, focuses solely on the language or provision itself. Balancing both approaches, therefore, will ensure the comprehensive application of the provision's meaning and intent, taking into account both context and textual structure to apply it effectively to fit the scheme of the Act. As such, the concept of this code, Section 2(1)(e), allows the interpretation of the term court to be read keeping the object of statute intact, and the same should result in defeating the purpose for which provision, that is Section 29(e), was inserted. In the backdrop of these discussions here and above, coming to the case in hand, the decision rendered in magnum opus so-and-so, which has been relied upon the respondents, however, comes to their aid, as arbitrators in their present case were not appointed under Section 11 with the High Court. As such, by applying this judgment, a distinction can be drawn to hold that appointment of the arbitrator is not by the High Court under Section 11, the principal civil court or jurisdiction. In this case, the commercial court at Shillong will have the power to entertain an application of Section 29(a) for extension of the term, as no anomalous situation would arise therefrom. As such, by making use of the expression of Section 2 of the Act, unless context requires, the textual interpretation will be in tune with the contextual one. Accordingly, keeping in mind the fact the High Court of Meghalaya does not possess original civil jurisdiction, coupled with the fact Section 11 nor Section 29(a) do not come into play in the present case, as the arbitrators were not appointed by the High Court, the Commercial Court East Kharsil Shillong, being the principal court of original jurisdiction, will have a jurisdiction to and extend the mandate as prescribed by Section 29(a) of the Act. Revision petition dismissed, disposed of. Yes.
Obliged.
Obliged.
Any mention?
May please, Lordship. Lordship, I beg to mention item number 32, Lordship.
32.
Lordship, I've informed to the parties.
Yes?
I've informed to the GHTC.
No
You
objection.
have objection?
No, Your Lordship.
1 week, yes.
Lordship, Lordship. Much blessed, Lordship.
Yes, yes. Yes, Mr. Kumar.
My lord, I beg to mention item number 28 and 29, my lord,
Yes.
of hearing list, my lord. The similar matter is still pending before the Honorable Supreme Court, my lord.
True.
And it was last listed on 3rd April, my lord, and will be listed on 9 July 2024, my lord.
9 July, after the vacations, that means.
Yes, my
This is 2 matters of the 8 weeks, yes. As
My
the
lord.
connected
Your
matters
lordship.
pending for the Supreme Court, yes. Yes.
highly able lordship.
May it please Your Lordship. Your Lordship, I beg to make a mention of item number 31.
31. Apiona Ju.
I
Yes.
pray the week's time may be allowed, Your Lordship.
Why?
Some personal difficulty of the conducting counsel.
22 matter, 1 week, yes. 1 week?
Yes, also.
Much obliged, Your Lordship.
Follow no.
Item number 2.
May I please, the Lordship?
Yes.
My Lord, this is a contempt petition, my Lord, where my Lord's order has not been complied.
Where's the order?
My Lord, may kindly come to page 22, the relevant portion of the order, my Lord.
Yes.
Para 2, my lord, it appears that the matter is still under consideration by the respondent corporation, and to this effect, representation dated so and so with regard to the claim of the petitioner is pending consideration.
Yes.
In this view of the manner, my lord, parties agreed that the writ petition be closed and the corporation be directed to dispose of the
Mr. SD, you accept notice?
My lord, I have been informed this morning, my lord. I'll be appearing on behalf of the, if I can be given a copy of the
Yeah, I'm
petition.
serving it right now, my
The
lord.
issue notice. MS Arakolni on instructions has tendered her appearance today itself. As such, no further notice called for on behalf of the two respondents just after 2 weeks
My lord.
for instructions affidavits.
Item number 3.
Please, Your Lordship. Lordship, this is my second round of litigation regard to settlement of
What
petrol
has
pump.
happened?
Lordship,
Is
my
that
mismatch in the PAN card, Lordship.
okay? No, I mean that retail outlet.
Retail outlet.
Yes.
Now, Lordship, on the first round, I have approached this Honourable Court because my representation was not disposed of. Now, Lordship, in the meanwhile, they had disposed of my representation, citing that
Where is that?
that will be at page 37.
Yes.
37 is the impugn order, Lordship. Now, this says that the deficiency or the mismatch in PAN card is non-rectifiable deficiency, Your Lordship. So that's why, like, they cannot accept my application. Now, Your
Have they
Lordship,
settled the retail outlet? Anybody as yet?
to my knowledge, they have not settled it, Lordship.
Okay.
Now, Your Lordship, may kindly come straightly to the guidelines. Because the rejection order was passed on the premise that the PAN card, there's a mismatch in my PAN card. Now, may kindly come to the brochure, Lordship, which is at Annexure 11, page 40. What is the purpose of PAN card insofar as this particular retail outlet is concerned? Annexure 11, Lordship, page 40.
Yes.
Lordship, may kindly come to page 42. The relevant page will be at page 42. Now, sorry, Lordship, may kindly come to page 41. 41, point number 4, Lordship. Eligibility criteria for individual applicants. 1, citizenship. 2, residential status. 3, PAN card. Now the next line is the next page, Lordship. Subclause 4, age.
For age.
Age. Not less than 21 and so and so and so. Now after that, Lordship, is the next para. Proof of age should be supported by
Where are you reading from?
page 42.
Yes. Age.
The age. Now the next,
Oh, I thought age as an age. Yes.
the sub-para, Lordship.
Yes.
Proof of age should be supported by copy of 10 standard board certificate, 10 standard school living certificates, secondary school living certificate, birth certificate, passport, identity card issued by Election Commission, PAN card, Aadhaar card. So the purpose of PAN card in this context is for the purpose of age proof.
How do you say that?
Lordship, this is the brochure.
No, this is 3. This is 4. 4 is totally different thing with regard to verification of age. You can furnish any of these, testimonials. But 3 is PAN card only. You have to possess a valid PAN card.
Lordship, that is
Yeah.
my. So I have a valid PAN card. Now that valid PAN card is for the purpose of my proof of age.
No.
Like, can you see the
So
Lordship?
3 is
Can
different. See, 3 is different, 4 is different heading altogether. Educational qualification different, age is different, lands different. Age you can furnish any documents, any of these other documents.
Exactly, Lordship.
But PAN you must possess a valid PAN card.
Lordship, the valid PAN card is for the purpose of proof of age. I'll show you,
No,
Lordship.
no.
I'll show you, Lordship.
How? That doesn't make any sense.
Lordship, may kindly come again to page 43.
Yes.
Page 43. The final processing of application, Your Lordship.
Yes.
Just in the middle. Final processing of application of provisionally selected candidate and documents to be submitted by the provisionally settled candidate before the FVC. Now the
Yes.
petitioner is provisionally selected in this case. Now these are the documents where it's required to be submitted by the selected candidate.
Yes.
Now 1, documents, notarized affidavit. B, proof of age, date of birth, self-selected. Now you'll see PAN card, Your Lordship, at the bottom. 1B, proof of age. PAN card is the document which is required to be proved to
And
be
ID
submitted.
card by Epic card also.
Epic card also, Your
Birth
Lordship.
certificate, passport also.
Lordship.
School certificate also, Aadhaar card also.
Lordship. Now, for the purpose of proof of which I have submitted my PAN card. Now, Your Lordship, may kindly come to my application form.
No, one thing, Mr. Nampur, you confine your submissions to why the PAN card was rejected. Why was it rejected?
Because there was a mismatch, Your Lordship.
Then can a mismatch be corrected as per the guidelines?
Lordship, the purpose...
Allow for mismatch, or is more substantial kind of error that can be corrected?
Lordship, my humble submission is that the PAN card which I have submitted, that is for the proof of age, Your Lordship.
I don't think
now,
so.
may kindly see the application form, the date of birth which I have entered, and the PAN card which I have submitted along with the application. There's no mismatch to that effect, Lordship.
I don't think argument is...
Lordship,
Where's the application?
Lordship, may kindly come to page 18, annexure 2.
I don't think that argument is good.
Annexure 2, page 18, Lordship.
Even the same heading you can understand. Yes.
Lordship, may kindly come to 11.6.
Yes.
11.6. The date of birth as entered by the applicant, by the petitioner, is 24th August 1992.
Okay.
Now, 11.7, Lordship. Next point. Document relied for proof of age, PAN card.
Okay. They've immediately accepted this.
They accepted this.
No, I think you're on a wrong premise here, arguments. The thing is, we don't relate age to PAN card. You've used it as a PAN card for age, verification, fine. But if there's a mismatch with regard to name or regard to number,
there was a number.
What is the
number,
rejection?
Lordship, the number.
Then?
Lordship, my contention is that the...
No, we understand. Last time when you came, we said that there's a mismatch,
Lordship.
and that error does not amount to, that does not disable your application. Correct?
Lordship.
Now I count different case for verification of age. I don't think that's makes
Lordship,
sense.
there's a similar set of case which was disposed of by Andhra Pradesh High Court on similar set of facts and circumstances.
No, I mean regarding reconsideration, why not? Why can't you reconsider it? Mr. Jindal? Doesn't mean it has to be so straitjacketed that just a small error in a number that a person loses whatever legitimate expectation they have to take outlet.
Lordship, unfortunately, my lord, in this matter, like I pointed out in the previous round, we are bound by the guidelines issued by Ministry of Petroleum.
Very good.
So in the guidelines, my lord, there are two sets of defects. One set, my lord, is a rectifiable defect. One set is a non-rectifiable defect. So the Ministry, in its wisdom, has imposed these guidelines on us, saying that you can rectify these sort of defects, but you cannot rectify the other sort of defects, including mismatch in PAN card. We are bound by the guidelines, my lord.
Mismatch means mismatch to what extent?
Mismatch,
mismatch?
For example, my lord, in this case, there was a mismatch in the numbers in the PAN card, card number. 1 letter, 2 letter. With respect, it's Lordship will allow me to file a small response.
Where's the guidelines that you're following from the ministry?
They are not attached with this writ petition.
Produce it. Otherwise, then you give instructions. Where's Dr. Mozika? You can't have this kind of such straitjacket. They have to modify the guidelines also.
Lordship, the impugn order.
If one mistake is made, for the rest everything is all right. Person not allowed to rectify one letter and loses his entire. It is gone to all the trouble of applying everything, and even shortlisted also.
I issued a judgment, Lordship.
Well, the notice be issued, my lord.
Yeah, notice will issue.
I'll place this judgment.
And no settlement was owed anybody in the time being.
On the last occasion also I had pointed out that we are currently under the model code of conduct.
Doesn't matter, as long as it matters. Otherwise, it becomes absurd.
May I please this judgment? Lordship, in this judgment, there was a mismatch in the survey number of the land document. Now, the respondent in that case have also relied on the same guidelines.
Non-rectifiable.
Non-rectifiable.
It's written here.
Lordship.
Yes, where's the
Same guidelines.
paragraph?
Lordship, may I kindly see this honourable court has relied this the matter, and they had relied this matter on the principle of reasonableness, saying that the impugn order is against the principle of reasonableness.
Yeah, take notice. Yes, heard Mr. Eman Nongpur, counsel issue notice. Dr. N. Mozika is present with so and so and accept notice on behalf of the respondents. Number.
I'm for 2 and 3, my lord.
Number year for number 1. And Mr. S. General is present accept notice on behalf of respondent 2 and 3. The grievance with petitioner, next paragraph, is that due to a mismatch in the PAN card, though the petitioner was shortlisted for award of RO dealership, the same has been rejected due to this stated non-rectifiable deficiency. Step. List after
2 weeks, man.
2 weeks for affidavit instructions. So misunderstood it's made clear that during the penance till the next date there shall be no settlement of the RO with any other party in question. We can't have this kind of,
Item number 4.
Yes.
And that age is not connected to the PAN card at all. That's a wrong premise. Yes. Yes.
Please, Lordship. This petition,
Yes.
Your Lordship, petitioner is a daughter of the deceased employee. Deceased employee actually is a regular service. He was
Petitioner
regularized.
is
Daughter of the deceased employee.
Where's the wife?
No, he's the daughter. The mother
The
was.
wife didn't come.
Lordship.
Well, mother should be of this person should be.
Yes,
the,
mother died in harness. Now the petitioner is a
the
daughter.
mother was
Yes. Now petitioner is coming for terminal benefit. Petitioner was not disputing that he was regularized, that the deceased employee was regularized in the year of 1987 by the recommendation by the District Selection Committee. Now she died on the hardness on 10th March 2020, supposed to be retired on 2023. But then now he's coming only for
on?
the petitioner coming only for the
No, died when?
Died on 10 March 2020.
Okay, yes.
I accept notice on behalf of respondent 1 to 3. 1, 2, and 3.
Yes, sir. Mr. P.T. Sama issue notice. Mr. H. Abraham accept notice behalf 1, 2, 3, and Ms. Sakib Prasad for present accept on behalf 4. No further notice called for. List after 3 weeks for instructions affidavits.
Lordship. Much less, Lordship.
Item number 5.
Lordship, the respondent have filed their affidavit, and I pray that I'll be allowed to file my rejoinder.
Rejoinder?
Yes, ma'am.
Contempt?
Yes, ma'am.
Contempt.
Okay. Mr. Jeshla prays for the allowed how much time?
2 weeks time.
Time for rejoinder affidavit filed by the respondent. Is thereafter also.
Item number 6.
Obliged, Lordship.
My Lord, we are in the process of filing the affidavit today, my Lord. We have served the advance copy to the petitioner, my Lord.
You see a copy?
Yes, Your Lordship.
Mr. Chandra submits that the affidavit on behalf of the respondent filed the post 30. So, you want to file rejoinder?
Yes, Your Lordship, I file rejoinder.
Please, after 2 weeks, file rejoinder, if any.
7.
6 and 7.
7 are connected.
Connected matters.
8.
Your Lordship, I kindly pray for 2 weeks' time, Your Lordship, to
One
file the
second.
affidavit.
Let the file come at least. Yes.
And for the
Where's the
respondent,
petitioner? Yes.
and for the respondent number 5, Your Lordship, I kindly pray for 2 weeks' time, Your Lordship, to file affidavit.
You already played before for that time.
Yes, Your Lordship.
How many times you played?
3 times, Your Lordship.
Many times.
3 times, Your Lordship.
Yes. None appears as a petitioner. Further 2 weeks' time allowed to respond number 5. You already filed. Well, yes.
9.
Your Lordship, I already taken steps.
Office note indicates that service is here not complete on form number 6. Lists after 2 weeks. Petitioner also to obtain status of service in the meanwhile.
10.
May I please, Your Lordship, we've already filed our affidavit, Your Lordship, for the state respondent.
What about
We're yet to file, Your Lordship.
7?
We're yet to file, Your Lordship.
Yet to file. When will you file? Course of the day.
Your Lordship, I'm yet to receive some further instruction.
I can't hear you.
Yet to receive further instruction, Your Lordship.
Yes, MS Alingwa submits that the affidavit on behalf of 1 to 6, 8 and 9.
Your Lordship, only 1 to 6.
1 to 6 has been
8
filed.
and 9, they're not parties, Your Lordship.
Oh, it has been stock of it. 1 to 6 has been filed. MS Ivasa for the council have a praise for 2 weeks for the time to file affidavits. Praise allowed list after 2 weeks. Yes.
11.
Your Lordship.
Ada file.
May I please, Your Lordship?
Yes. Yes.
We have filed the rejoinders.
To all the
Only one
respondents.
is left.
What about 2 and 3?
2 and 3.
You
We
have
have
filed the
decided that we will not file
To 2 and 3 you won't file.
because it's all the amendments and contentions
you
made
will
us.
not file,
We will not
that's all.
file, sir.
Will list for hearing then?
Lordship, yes.
Party submitted pleadings are complete, and that the parties are further complete. Accordingly, it's a matter for hearing. And so on. So yes.
Next item also same.
What's the matter about?
This is regarding
Recruitment.
Recruitment, Your Lordship. Okay.
Yes.
Much obliged, Your Lordship.
13.
Lordship, I'm praying 2 weeks time, Lordship, to file
what?
rejoinder, Lordship. Private respondent have filed their.
Mr. Chandra prays for to all the respondents.
Lordship, only private respondent.
My
Others
lord,
have not.
5, 6 and 7 is MECL, my lord. Which
You're not
will-
filing?
No, my lord.
What about
So
8 to
far.
12? 1 to 4?
Statement.
1 to 4 filing or not? No, already filed.
No, my lord. Only the private respondents have filed.
Kindly see the last order, 3/4/24. State has also said that they won't be filing any affidavit.
Yes. Okay. You already filed the other ones.
Lordship.
Mr. S. Chandra prays for is allowed further 2 weeks time to file rejoinder to the affidavit filed by respondents 8 to 12. Yes, accordingly also.
14.
Where is the petitioner?
Yes, MS GT Sangma.
May I please, Your Lordship?
You've served with 1 number 6, correct?
Yes, Lordship. It's
Well,
delivered
affidavit
also,
service.
Lordship. It's delivered also. Some more time to file the affidavit,
File
Lordship.
Service then, for
Yes,
number
Lordship.
6. What about affidavit?
State file, Your Lordship.
May I please, Your Lordship, for respondent number 5, 1 week's time is required, Lordship.
Sorry, your name?
B. Rapsang.
Yes, MSB Rapsang for 5 praise for allowed further 1 week's time to file affidavit. MSGT Sangma for the petition also praised that he will have similar time to file an affidavit indicating service upon the respondent number
6, Lordship.
6. Yes. These are also.
15.
Lordship.
Lordship.
Your Lordship, I'm praying for some time on behalf of Mr. M. Sengkon to file the affidavit in opposition.
You appeared last time, 1 to 5.
On his behalf,
I don't see Mr. Sinkon's name anywhere.
Similar prayer, Lordship. I am appearing on behalf of the private respondent, Lordship.
Yes, Ms. Hassan.
Okay, Lordship.
For the 2 weeks' time, as prayed by Azad Dari Non-Country GAF 1 to 5 and SA Sheikh for 6.
Obliged, Your Lordship.
Obliged.
16.
For the time as well for 2 affidavit as prayed by so.
Lord, here I am praying for some more time.
I'm awaiting instructions.
There was a similar prayer also. I am for 6.
Why instructions? It's a 23 matter. What's the matter about?
Regarding appointment, Your Lordship,
Appointment to what?
of the petitioners, assistant teachers.
Assistant teacher?
Yes, Your Lordship.
This came up on motion this year.
You're appearing for whom?
I am for the private responsibility. 6.
Managing committee. 2 weeks time as granted to the respondents, 1 to 5, that's also the respondent 6. Yes, yes, thereafter also.
17.
This is against execution, my lord. There's a direction passed by the court below, my lord, for attachment of the office of the chief judge, my lord. My lord, during the pendency of the matter, we are in the final stage of processing the payment, my lord. If the matter is fixed up to 2 weeks, in the meantime, we'll deposit the money.
How much amount?
More than 2 crore rupees.
You're aware? How much? No, not aware of the amount. You have any instructions?
Lordship, ma'am was supposed to appear. The file is with her, Your Lordship. There's the thing. She's facing technical difficulties, Your Lordship, that she couldn't connect.
Dr. N. Moskia submits that the process for payment of the dues of the petitioner, of the respondent.
My lord, actually, it is not a final payment. Because what happened, my lord, we have filed an appeal against the award, my lord. That was a belated appeal. So
anyway, whatever
appeal is a deposit, my lord.
Your Lordship, the appeal was time barred, Your Lordship. They filed the appeal with the continuation of delay, Your Lordship, for 1,000 days. 1,000 plus days, Your Lordship.
To that we are
okay, we listed, tell your ma'am to appear day after tomorrow.
No, Your Lordship, first week of May, Your Lordship. She won't be available, Your Lordship.
First week of April?
May.
My lord,
first week of May.
By then I think we'll resolve, my lord.
Dr. M. Moskia prays aloud for the time to obtain instructions. Start according to this matter.
First week of May.
In the first week of May.
18.
It's a connected matter. We are adopting the same position as in other TPs.
What is this?
Transfer petition. It's connected with transfer petition criminal number 2 of 2019.
It's being heard, listed today.
Yes. My lord.
Oh yes, we heard of some time. Yeah,
Item 38, my lord. It's item 38.
19.
I'm praying for some more time, my lord.
No objection, my lord.
2 weeks further time is prayed allowed. Affidavit.
Hearing. Item 20.
Lord, this is a squarely covered matter and already implemented the judgment in favor of the similarly situated trade of Assam Rifle, Your Lordship.
Which trade?
They belongs to, my lord, they are in electrician trade. Earlier, my lord, the learned division bench passed the judgment and they have challenged before the Honorable Supreme Court. Supreme Court upheld the division bench order.
When was it upheld? That was many years ago.
No, they are extending and division bench recently also, my lord. Your Lordship's order, Lordship may look into the order dated. 3 orders I am, 19/6/2023, Your Lordship's order.
In fact, 28 and 29, my lord. These are all connected matters, my lord. And item number 28 and 29 were mentioned.
Adjourned today.
Adjourned today.
Why do you say this trade? Why is that covered?
My lord,
Lordship already observed it.
My lord, in the second
Where?
round.
In
Lordship.
that passed by this bench.
No, Your Lordship already earlier also gone through the judgment, and Lordship may kindly look into the order sheet dated 19/6/2023, 12/9/2023.
19/6.
Yes, Your Lordship. It is part heard.
Why is it lying for?
19/6/2023. Then, my lord, 12/9/2023.
Now the matter is dismissed. Supreme Court when?
It's not been dismissed. It's still pending.
No, my lord. It is already implemented. I am showing the implementation order I have enclosed.
It affects those other contempt matters also, 2 of them.
Yes, madam. Madam, contents were disposed of. Several contents were filed, my lord. Because in the order passed by the division bench, madam, no fixed time frame is given. Madam. It only says implement preferably within a period of 6 months. So the contents were disposed of by Lordship, my lord. Now the SLP filed by us is still pending before the Supreme Court. Well, that was the reason item number 28 and 29.
Annexure 10 and 11, they have already implemented, my lord.
10, 11 of?
Of my writ petition.
But it's fine, 2019.
Page 117 and 118. Lordship may straightway come to 118. It is 21st February 2017. I am directed to convey the approval of the competent authority for upgradation of the redesignation of the post of Rifleman ORL to Havildar ORL in Assam Rifle in respect of the personnel who are similarly placed and have not been upgraded, redesignated earlier in the revised scale of 3,200, 4,900 with effect from 10/10/97 or from the date of passing of ORL class 3, whichever is later.
But the present petitions are not ORL, they are litigation.
Same technical trade, other, your lordship, the division bench judgment also I have given a compilation. As many as 15 judgments they have in their affidavit, they have says that writ appeals are pending and those writ appeals have been dismissed.
They were selected as rifleman electrician.
My lord. Some are direct recruited and some are by way of remastation. And even your lordship.
So now you want a Havildar electrician?
Yes, it is a benefit of 5th pay commission, 3,200, 5th pay commission benefit. And benefit cannot be confined to a particular trade. Riflemen, all riflemen are same, my lord. These belongs to a trade. Riflemen, Havildar, these are all trade lordship, cadre post of Assam Rifle. So benefit of a 5th pay commission, because I am here, my lord, asking for the extension of the benefit of the judgment of the division bench dated 22/9/2011, page 81, your lordship.
Famous judgment.
So only, my lord, that.
Is in a hurry, my lord, but if the final word is
No, I am also not keeping very well, my lord. And the petitioners have abandoned me, my lord. Very fairly speaking, my lord. And not keeping well.
So it's very good of you not abandoning them also. Yes.
Benefit of this judgment, my lord.
Yes, we'll pass orders.
Madam, some more matters are pending and those are being adjourned, my lord, on the ground that matters pending goes over. Now, if these matters are disposed of, my lord,
let them go to, my lord, because already they have implemented. Already they have implemented.
My lord, if Supreme Court says finally, my lord, we will have no other recourse.
My lord, I have placed one judgment, my lord. Same plea was taken by my friend before the other learned single judge, his lordship, where last para your lordship may look into. Last para 37. Dispose of the matter. Same plea was taken.
Well, matter can be disposed of by a direction, my lord, whatever the outcome of Supreme Court, that will apply to them.
Yes.
Para 37, your lordship. Para 37, last page.
There's no point keeping it pending also. If you actually do not dispute the fact that rifleman electrician is...
We are more qualified than the ORL. We are more qualified.
If all the trades have been brought under inadvertently by you, why should you leave out any other trade in the rank of
That is what we have taken in SLP.
Initial plea is that there was a mistake by you only. The court did not grant you that you across board all the trades that you give, but then you granted that benefit, and then you can't be selective now and say okay fine, you don't extend the benefit to one trade and you like cipher and other things you've given them. So and with these cases we're just like a dog running after its own tail. So I mean it is not getting anywhere. What do you say, Mr. Chanda? Like a dog running after its own tail.
As of now, yes, my lord. But if Supreme Court finally says something, my lord.
No, already said, my lord. Already said and implemented. Already said and implemented. Page. page 118, there are orders, my lord. And my friend also argued in Digambar that case. My friend has argued before the learned single judge as well as before the division bench.
What Digambar Das?
Digambar Das, that one of the similar, same case.
It's not before this court.
No, my lord, I have compilation, I have given that judgment.
There's no compilation.
There is a compilation, my lord. There are two implementation orders also given. I have given a compilation of judgments also. My friend was the counsel for the in the compilation, page 48, my lord. Digambar Das.
Which compilation? Two compilations.
There are two. One is implementation orders.
Yes.
And other is judgments of this honorable, various judgments of this court, my lord.
Yes.
Various judgments.
Yes.
So, my lord, I am asking for extension of the benefit of judgment serial number 2. Writ Appeal 50 of 2010, which was upheld by the Honorable Supreme Court, and benefit was extended.
That same order of Justice Hazarika.
Yes. And then, my lord, similar issue came up, serial number 4, your lordship. And division bench also said, serial number 3, Mahesh Kumar, your lordship. They said all similarly situated employees should be given. Otherwise, within 6 months, otherwise it will carry interest of 6%. Yes. Mahesh Kumar judgment.
Take down his. How many petitioners are here?
My lord, here 143.
140.
This is 143, my lord.
143.
My lord.
The petitioners in the incident petition numbering.
One submission, my lord, division bench were deciding the matter against which we filed SLP, my lord. Their division bench of this honorable court, my lord, said that at this stage, this court cannot reopen the matter. Only Supreme Court can reopen the matter. Though the court was satisfied by my arguments, my lord, but saying that to maintain judicial discipline.
Very good. Then we maintain judicial discipline. We allow the petition also.
If Lordship allows in that direction, my lord, at least we will have.
Where's the last division bench order?
Mahesh Kumar, my lord. That is serial number. Lordship, last division bench order.
We are bound by the
page 36, your lordship. Page 36.
36.
Yes. And relevant page, your lordship will find.
No.
Attain finality, para 15, page 43. My lord.
36.
Page 36 onwards, this judgment. And lordship may page 36 onwards. And relevant page, your lordship will find first, page 41. Page 41.
We will not dwell on the fact and we will not go anywhere.
My lord, only extension of this benefit. Extension of this benefit. That will do, my lord. And here, your lordship, in the last para, it says all similarly situated should be extended. Page 47. It hoped that entire benefit will be extended to the writ petitioner respondent and all similarly placed personnel of Assam Rifle within 6 months from the date, failing which the monetary benefits and the monetized value of other benefits will carry interest at the simple rate of 6% per annum from January 1, 2019 till the date when the entire benefits are made available.
The writ petitioners numbering, how many numbering?
143, my lord.
143 number. Are before this court seeking grant of, who are stated to be rifleman electrician.
Rifleman, Havildar. By this time, someone got by promotion. Otherwise, they will get from the anti-date. If the
rifleman stroke Havildar.
Havildar. Electrician. MB.
Bracket. Problem? For this court, who was serving as
rifleman electrician, Havildar electrician MB.
Havildar
electrician MB.
Rifleman electrician and Havildar electrician are before this court praying for grant of appropriate rank, status and pay scales of Havildar electrician, bracket capital MV, at the entry grade as per recommendations of the 5th Central Pay Commission, comma, Office Memorandum dated 22nd January 1998, read with Ministry of Home Affairs letter dated 28/7/1998, comma, DGAR's order dated 21/2/2017, and as also in the light of the judgments and orders passed in writ appeal number 50 SH of 2010, dated 22/9/2011, judgment dated 23/5/2014, passed in WPC number 218 of 2013, and also the most recent judgment dated 24/2022, passed in WA number 10 of 2022, and other connected matters. Stop. Approval of the pleadings as also the approval pleadings and on hearing submission to counsel for the petitioner. It is evident that the petitioners who were initially recruited as rifleman electrician following a due selection process constitute one of the trades for which exercise of remusteration had been undertaken by the respondents pursuant to policy decisions and fortified later by orders of the earlier jurisdictional High Court and also the present High Court. Next paragraph. With respect to the latest judgment, the most recent judgment passed by this court, dated 24/2022.
19 and 20.
This court at para 19 and 20 had observed as follows. Page 45 compilation. And had concluded judgment by extending the benefits, entire benefits, to similarly situated personnel of some rifles. So your some rifles stop. The next part, the applicability and the need for compliance with orders is not disputed by the learned DSGI Dr. N. Musica, who however submitted that an SLP has been preferred against this order, which is pending consideration. Be that as it may, as similar benefits have been extended to all other trades, this trade petition is also accordingly disposed of by affording identical relief as given in WA number 10 of 2022.
Subject to decision of Supreme Court.
It'll always be subject to decision of Supreme Court. If it allows you to take it away, you might say henceforth no.
My lord, next item is also same, my lord.
Yes?
Next item is also same. Same order.
Same order.
They are electrician. Deeply obliged, your lordship. Deeply obliged.
Yes.
22.
How come this matter was before the CJ's bench?
There are two connected matters have both been sent back to the original courts. It was supposed to be listed today before His Lordship, the Chief Justice.
What's the matter about? First time it's come here?
Promotion in the Education Department, Your Lordship.
Yes.
I'm paying for some time. After 2 weeks. Why it has been listed? I don't know. I think only because the date was fixed today, my lord. The bench
On the prayer of the Council of Parties, this matter after
2 weeks.
2 weeks, yes.
23.
Be pleased, my lord. My lord, this matter has been fixed along with the next matter, my lord. The petition.
Yes?
My lord,
Where are the councils? Call them. We'll...
My lord.
24.
And 24. Next matter, first, this to be taken up first. This to be taken up first, you're saying?
My lord, we have prayed that the revision will be taken up after disposal of the writ petition, my lord.
Okay.
My lord, in the writ petitions, we have suggested 2 persons to be appointed as a inquiry officer. And last time, my friend's colleague has taken some
So
time.
let's start Lingdo and Shai Boralang Walang.
So, my lord, my instruction, my lord, we are agreeable to the first name, my lord, Relay-Star Lingdo.
Let's start Lingdo. Who is he?
My lord, he is Lingdo of Novosopo, same, my lord. My lord, only on the condition, my lord, since the petitioner has been suspended, my lord, he should also take care of the administration, my lord, in the interim.
The inquiry officer.
Yes.
How would he ask
He is a neutral
after
person.
the administration of the...
He is a neutral person, my lord.
My lord, since another friend has submitted, he has been placed under suspension, and now 2 names has come forward. He has no objection with regard to number 1. Now, my suggestion, my lord, prayer would be let number 1 proceed for inquiry, and with regard to the affairs of his area, the chief will look after for the time being. That will be fair. The inquiry officer cannot look after the affairs of the...
The chief is already there, my lord.
No, it cannot be done.
The chief is what?
Chief is on the other side, my lord.
No.
That's the difficulty, my lord.
It cannot be.
Somebody independent, my lordship appoints, my lord. Or district council can...
Even the shortcoming we have realized is that I have appointed one of the complainant as a acting. That is the only shortcoming. Otherwise, my lord, it is the power of the chief to place him on the suspension.
But we are agreeing to this much, my lord. They should agree to that much.
No, that's, if justice be done, should be done in a proper manner. Not you already nominate the person who will be acting, this and that, everything.
That is why, my lord, that is why we come up with a fresh name. For that purpose, who should be conducting the...
Where is the order dated 21/3? Yes. Yes. Now what about the administration Vilaka? They do it to the same. Yes.
It's only for clan, my lord.
Only for clan.
For clan. The dispute is with regard to Lingdo of the clan.
Then then there's no necessity will be acting like order. Not necessary. Is it necessary?
It's not that comparing, but in case if the situation arises, I think the chief can look after. Otherwise, it's unlike the full-fledged administration of the same chief. It's one particular claim.
Different plan, from this place.
Mr. Dindo appearing for whom? Who's 2 and 3?
Well, actually, the discouncil has not been made a party in this case. If the discouncil had been made a party, perhaps we could have entered the arena and took over the administration. Because here, the dispute is between the clan members. And the other case, the second appeal, that is in respect of the, it's related.
So if we dispose this off now, this will be ripe for hearing. Or we'll have to wait.
Perhaps we'll have to wait. Let a time frame be given, Manoj.
First day.
How much time will be practical?
Maybe for 2-3 months, my lord, inquiry.
3 months.
And the chief will pass a.
Be there. It will be too long.
That will be too long.
2 months.
2 months or so.
And interim arrangements?
Interim
arrangements suitable to both all the parties?
That is why, my lord, I'm not, though the allegation is there from my friend's side, but I'm not involved in this. Being the head of the Ilaga. So if situation arises, my lord will allow me to look up to take care of the administration for the time being.
Orders that might create, like say, anomalous
I think
situation.
let the chief look after the, for the time being.
For the time being.
That would be
Any issue arises, they can approach the chief.
Yes. Right.
Okay. Pursuant to order dated into this court by order dated 21/3/2024 had directed as follows. So court, stop. Next paragraph. Subsequently, on 5/4/2024, the Learned Senior Counsel, on behalf of the respondent number 1, had supplied the names of 2 persons, namely number 1, Relestar Lingdo, RELESTAR Lingdo, and 2, Shai Borlang Walang. Stop. On instructions being received, Dr. M. Mozika, on behalf of the petitioner, has submitted that they are agreeable to Sri Relestar Lingdo being appointed as the inquiry officer to conduct the deed over inquiry. In this view, the matter should dispose of or leave it for required to come back to court. Dispose of.
Dispose it off, my lord.
Yes.
And the chief will pass appropriate order.
Yes. In view of the
Liberty
matter.
to us, my lord.
Yes. In view of the matter, this writ petition is disposed of the stage itself by appointing the said Relestar Lingdo to be the inquiry officer to adjudicate upon the matter pertaining to Lingdo Palayar Mokarda. Yes, it is pertaining to Lingdo Palayar Mokarda. Okay. Come again, sorry. The matter regarding the appointment of Lingdo Palayar. Oh, Palayar comes first, Mokarda comes first. What comes first?
Page 21, man. It is mentioned there. Page 21 of the petition. Lingdo Palayar Mokarda.
Okay.
Kente.
Ayo. Lingdo Palayar PLR Mokarda MAW faring MRKYRDA like po bracket like in Thai clan. Ayo, just read it again. the appointment of Lingdo.
The complaint against the petitioner.
Also pertaining to the complaints against the Lingdo of what so and so. The same as some of the parties can be should be completed, or the same should be completed within 2 months from the date of receipt of this order by the respondent number 1. Yes, in the intervening period, should any issue arise with regard to the matters within the said clan, the same shall be referred to the respondent number 1 for clarification or decision.
In fact, the acting Lingdos were appointed. Should be unseated, my lord.
Who acting Lingdo?
Respondent number 2, my lord.
Then acting Lingdo should go in the meanwhile. Where is that?
71.
The impugned order itself, my lord.
Is the impugned order, page 71A.
Oh yes, nothing. It's also provided that, as in the complaint itself, the name respondent number 2 had been this Bhai Berlin Palyar.
Well,
the respondent had been suggested to be the acting Lingdo, which was acceded to by respondent at that time. The said Shri Bhai Berlin Palyar Prakran shall no longer function as acting Lingdo till the disposal of the inquiry and orders passed thereon by respondent number 1.
Well,
23, what to do? Where's...
We'll have to wait the outcome because acting Lingdo and the Lingdo is a party.
Yes,
suppose he is removed, then...
As this matter is connected to the disposal of inquiry as directed by in WPC number 214/2023, this the same after 8 weeks.
25.
What's the matter about Mr. Jha?
My lord, this is with regards to that fake domicile, my lord. Based on that, they have alleged that it is a fake domicile, my lord.
West Bengal?
West Bengal.
Why has it been lying pending without disposal? This matter, I think it was heard once.
My lord, it was.
Why? Let's see. One. Why did you file a supplementary affidavit, bring on record this other?
My lord, that was inadvertently the certificate which was issued. It was not annexed in the writ petition, my lord.
So where do you go? How do you proceed this hearing now? What were your submissions earlier on?
Earlier, on my lord, the impugned order. Impugned order was passed based on the inquiry, court of inquiry, my lord.
Yes.
And, my lord, the impugned order is at page annexure 8, my lord.
Section 8.
Page 38, my lord.
Page
38, my lord.
38. Yeah. Was the charge?
Mal.
You served only 8 years.
Mal. And it says that, my lord, the said not related to the office, my lord. It does not say that specifically it's a fake. The order which.
Yes, it said where and what in the affidavit, what have they said?
Affidavit, my lord, it's interesting, my lord. My lord, if I take the affidavit filed by them, my lord. My lord can come page para 2B, my lord. 2B.
Who filed a complaint?
My lord, that's interesting. No complaint. The copy of the complaint is also not produced in the court of inquiry, neither in the court of inquiry, nor the person was examined in the court of inquiry.
See what they say in B?
B, my lord. They say that, my lord, a complaint was filed on December 2016, my lord, in the PMO office. PMO office, my lord. Prior to that, my lord, on 8th, in the month of August, my lord, 11th August 2016, my lord, a convening order of a court of inquiry was initiated, my lord. A court of inquiry was initiated.
Against you?
Against me.
Before the
the complaint was, it's a putting a horse before the cart, my lord.
No, what happened? Where's the complaint? Where's
Nothing.
that order constituting the...
Court of inquiry, my lord. My lord, page 28 of the writ petition.
Convening order, 11 August. Okay.
My lord.
Page 28. COI 11-8. Okay. And as para 2B, you say the complaint is filed by so and so.
So and so in December.
Okay.
Nothing was brought on record. What was the complaint? Neither in the court of inquiry, nor before in the affidavit filed by them, my lord.
Yes. Yes. Then 16.2, maybe it's just a typo. Are you sure it's correct? It's not 16.2.
No, my lord. It's my lord can.
Are the records available? See, it might be a typographical error.
It appears to be typographical.
It can be 16.2. It's impossible.
How
can a court of inquiry be instituted even before a complaint is filed?
That's a more
Are you such important? You just important officer that, that they will...
My lord, can that be, if that be so, my lord, they,
Your Havildar clerk.
they would have annexed the copy of the complaint, my lord. Cannot be a typographical error, mistake. The entire paragraph reads...
You produce the records. If this is, if you have to see first whether it's correct or not. If court inquiry was constituted in, where is that in?
It's...
See, because investigation level by, see, Prabhat Kumar Sharma, same thing, it refers here only. That means there might have been an earlier complaint before them. No.
I don't know, nothing. Court of inquiry is, my lord, copy of the court of inquiry is totally silent, my lord. Court of inquiry is totally silent.
Yes, can we clarify, Dr. Musika?
At this latest,
I'll produce the record. It appears to be typo only.
Might be a typo, might be a second complaint, 1612. I don't know, we'll not hypothesize. But
my lord, what is more important, my lord, also kindly see page 33 of the writ petition, my lord. This is the domicile certificate he filed, my lord. He produced for enrollment.
33?
33, my lord. Government of West Bengal.
Which page? It's
page 33.
Lecture?
But that is in. But you also see page. It's not even paginated, my lord. Immediately after page 30 of the writ petition, my lord.
Page 30. This
page 30 is
shown as annexure 4.
Government of West Bengal, my lord. Is it?
No, yes, annexure 4, page 31.
My lord.
With reference to the memo said above, it's one with a copy of the enclosed certificates related to this office.
My lord.
No, my lord, before that, in my copy, he has given the certificate,
my lord. My lord, page 30.
In the writ petition?
In the writ petition. Or I have annexed in my affidavit also, my lord, page 33 of my affidavit.
There's come supplementary affidavit of his.
Yes, 33 of my affidavit.
Yes. Yes. Yes.
That was the Government of West Bengal Office of the Sub-Divisional Officer, Southwest, Pragna.
Yes.
But my lord, there is no such subdivision in the West Bengal.
Even the Parganas?
That is a district, my lord. And there also spelling is different. Even whoever has made the certificate, my lord, is not cared to give correct spelling also, my lord.
Like once one deed was produced, in showing 1941 documents, some, on notarized paper, but the seal was Sub-Registrar East Khasi Hills. I hope it's not a similar situation, because that deed shows Sub-Registrar East Khasi Hills in 1941.
It's something like that. But in fact, I took out the printouts of the names of all the districts in West Bengal.
Where is that? The seal also is there, Officer Southwest Pragna.
My lord. And even, my lord, even the report, they say that...
Have you looked up in the internet whether this Southwest Pragna exists?
My lord, if my lord...
South 24 Pargana is one district, my lord. I'll just place this one.
So, if it's patent on the face of the record itself, that is fake. Then you have to pay cost.
Second last one, South 24 Pargana is one of the districts.
Sub-district?
No, sub-district, the next page, my lord, administrative unit. Alipur, Sadar, Barwinpur, Diamond Harbour, Kakdeep and Kandy.
So whether there exists such a place as Southwest Pragna?
That doesn't matter.
You've Googled it.
I've done
Google
this one.
Maps.
The next page, my lord. My lord, first one is the number of all the districts in West Bengal, 23 districts, my lord.
It does not say, it says subdivisional. That's why I'm saying whether it's a subdivisional office, something is Pragna, whatever. It's not a district, it says office subdivisional officer of Southwest Pragna.
So, my lord, these are the subdivisions and blocks. My lord, in the second page, lots you will see names of the sub-blocks under subdivision division. Alipur Sadar, Baruipur, Diamond Harbour, Kakdweep and Canning.
Might be more. Mr. Jha, before finding the matter, he didn't verify whether this place exists or not.
Which, my lord?
He didn't verify whether this place exists or not, the Southwest Pragna. But that's a very serious matter. If a seal has been made also, and who is the person who signed it also?
My lord, the best, even they have obtained a certificate from the concerned SDO. It says that it does not relates to this office.
No, we're not going to take that as gospel truth. What we're asking is whether we have to find out now whether you have to show the court that this Southwest Pragna exists. Firstly, for us to proceed. Where is it? Just Google, Mr. Guru, whether Southwest Pragna exists at West Bengal. Subdivision, Southwest Pragna, Pragna. Says the court. We can close the matter here only. Southwest Pragna, subdivision officer.
Lordship compares that page with page 31 or in my affidavit. Page 31 of the report. Lordship has seen that, of course. Once again, Lordship sees that. This does not relate to this office.
The Sadar Alipur.
Sub-divisional officer, Sadar.
Is there, Mr. Bhattacharya?
Not 24 Parganas is there, my lord.
Is one
no, that's all right. It's one district. But whether a subdivision such as this Southwest Pragna exists.
This is the name. Sub-divisional officer, Southwest Pragna.
South Pragna is there?
Pargana actually.
Pragna, Pragna.
No, it is Pargan.
No, Parganas is fine. But is there something south or west? Then?
South 24 Parganas is showing, my lord.
That's a district. Subdivision. Subdivision by this name. Southwest Pragna.
We'll come back tomorrow, we'll dispose it of. I think the levy cost. If this is a fake certificate that's been relied upon.
My lord, the fake certificate has to be, my lord, it's a.
No, you're maintaining the case that does not relate to this area. The fellow is taking a safe, but then they show that this exists. That's all.
Definitely, my lord. They have also done a police verification, my lord. If that be so, let them produce that police verification, my lord. If the exist, it does not exist, my lord. From where the police verification?
Certificate, sir?
Domicile certificate.
See, there's a seal also. That's disturbing. Officer Southwest Pragna, Office Subdivisional. Officer Southwest Pragna.
But you will see the spelling melody in the certificate. It says this is to certify that Mr. Vinay Kumar so and so.
Yes.
In the district of South 24 Pragana, even here the spelling is incorrect, melody. Government officials will not write incorrect English, melody.
Kasbah. Kasbah, where is Kasbah?
Kasbah
in Kolkata.
It's in Meghalaya House where Kasba is, my lord. It is in the city of Kolkata, my lord.
See, a village
Kolkata
of,
78.
see, was this apartment Kalinpur, Kolkata 78?
Kasba, then it says, my lord, Kolkata 78. It can't be Kolkata and Parganas also the same time.
No, but it's disturbing the seal has been made and attested by the senior medical officer, Urban Health Center, Ulubari. He also will be culpable now. It's a case of forgery and misrepresentation. I think Mr. Jai batting a very sticky wicket.
My lord.
You're on a sticky wicket. This one looks very apparent in the face of the record itself. By tomorrow, you come instruction that this exists. Otherwise, it'll be. Your client's in town.
My lord.
Is your client in town?
No.
I'm sure he is in Bihar. This looks like it's been made somewhere in India. Anyway, Mr. Arjab is allowed 1 day's time to ascertain the correct, to ascertain the, to substantiate that Southwest Pragna, Pragna, West Bengal, from where the petitioners obtained the certificate and given in the certificate dated 24,010 exists. This tomorrow is.
$26.
Lordship, I pray this matter may be passed over, Lordship. Counsel for the petitioner is on his legs in court number 4, Lordship.
Who?
Mr. Jobshalla.
What's the matter about?
The pension matter, District Council.
After 1 week. Yes.
God bless.
27.
Strange, Pragna. Yes.
May I please, Your Lordship?
Yes.
Lordship, here the petitioner, my lord, in the year 2001, my lord, he was recruited into BSF, my lord.
2001.
2001.
Yes.
Subsequently, my lord, in 2012, he qualified for the post of head constable, my lord, and he was transferred to Taliguri in West Bengal, my lord. For some unexplained reason, my lord, the new post, my lord, appointment was not given to him.
The
appointment to the promotional level, my lord, was not given to him for more than a 6 month, my lord. Subsequently, my lord, he was found to be HIV positive, my lord, and he was placed under, my lord, low medical category, my lord. So challenging that, my lord, the petitioner was before this honorable court, my lord. Subsequent to which, my lord, an order was passed directing the respondent authority, my lord, to give him the promotion, my lord, with effect from 2012. That is the date when he was qualified, my lord. Now, my lord, while, my lord, complying with the order of the honorable court, my lord, they put a rider, my lord, saying that, my lord, the date of the direction of this honorable court was in the year 2014, my lord. That is, seniority will be calculated from the year 2014 and not from 2012. That is the date of qualification, my lord.
Yes.
So, my lord, being aggrieved, my lord, a second round of litigation, my lord, the petitioner approached this honorable court. By virtue of which, my lord, please come to, my lord will come to the last order of this honorable court, my lord.
Page?
Is at page 42, my lord. If I may read, my lord, page 42.
Yes.
May I read, my lord? The case set up by the petitioner is that he was enrolled as Constable GD and was posted at the 7th Battalion Border Security Force. The petitioner had responded to advertisement notice issued by respondent number 2 in the year 2011, inviting application both from direct and departmental candidates for various posts, which include Head Constable Ministerial. He was selected as Head Constable Ministerial and adjusted in the 7th Battalion BSF, Taliguri, West Bengal. After submitting technical resignation in the 17th Battalion Border Security Force, he reported to the 7th Battalion BSF, Taliguri, West Bengal, but appointment order was not issued in his favor. After a lapse of 7 months, he was directed to report back to the 17th Battalion Border Security Force. Aggrieved thereof, he filed a writ petition number 323 of 2012, which has been decided by detailed judgment rendered by this honorable court dated 15 April 2014 and later dated 15 November 2012, which was impugned, was set aside, and respondents were directed to allow the petitioner to join the post of Head Constable for which he was selected. In compliance whereof, petitioner has been appointed as Head Constable in BSF with condition that his date of appointment will be counted from the date of joining, that is 14/08/2014. On the basis of this appointment, while reckoning the date of joining, that is 14/8/2014, in the seniority list of Head Constable Ministerial as issued, he figured as serial number 1415. The grievances of the petitioner is that the effective date of appointment should have been given as 25/4/2012, when after selection he reported to 7th Battalion BSF, Taliguri, West Bengal. For no fault of his, had been deprived of reaping fruits of his selection. The deprivation of the appointment on selection has been rectified with judicial intervention, that is in terms of judgment dated 15th April 2014, rendered in WPC number 323 of 2012. But a condition incorporated in the order of appointment as issued in compliance with the judgment to the effect the appointment will count from date of joining, that is 14/8/2014, is unwarranted, hence the instant petition. The facts are admitted. Now the only question for determination emerges as to whether order of appointments should have been given effect from the date 25/4/2012, when the petitioner on selection had reported in 7th Battalion BSF, Taliguri, West Bengal. The answer has to be in affirmative because no fault at all is attributed to the petitioner. He on selection as departmental candidate immediately tendered technical resignation to the 17th Battalion Border Security Force. Thereafter, without loss of time, reported to the 7th Battalion BSF, Taliguri, West Bengal, where he was adjusted. Once order of reversion to his parent department by not giving appointment as Head Constable for which he was duly selected has been set aside and appointment given, same has to be with effect from the date of the petitioner on selection and reported on the 7th Battalion BSF, Taliguri, West Bengal, where he was adjusted. Petitioner as departmental candidate was working as constable when he was not given the appointment without any justification. He has reported back to the parent department where he discharged duties till he joined pursuant to the order of appointment. To safeguard the right of the petitioner, the condition incorporated that petition appointment will count from 14/8/2014 has to be notionally from 25/4/2012 and monetarily from 14/8/2014, the date he joined as Head Constable Ministerial in BSF. The principle laid down in so-and-so, my lord, I'll come to paragraph 8, my lord. Division bench so-and-so, 9, my lord. The case of the petitioner is squarely covered by the principle as laid down in the above referred judgments. On final analysis, in view of the stated facts and law, this petition deserves acceptance as such is allowed, and condition number 2 in the order impugned to the effect that the date of joining in this unit, that is 14/8/2014, being not in conformity with the law, shall be ignored. Appointment of the petition shall reckon for the purpose of seniority and other benefits notionally from 25/4/2012 and monetarily from 14/8/2014, that is the date he joined as Head Constable Ministerial in BSF. Condition in the appointment shall be read according to the petition disposal. Now, my lord, what had happened, my lord, subsequent to passing...
So monetarily he was given from which date?
2014, my lord.
Same date which you will...
My lord,
no change in that.
I have no issues with that, my lord.
Only notional promotion from...
my lord.
From 2012.
That has not been
What
complied.
happened after this order?
After this, what had happened, they simply placed my lord, my position from one place to another randomly, my lord, consequent to which my lord, my juniors have superseded me, my lord.
Randomly meaning?
Randomly, my lord, without complying with this, my lord. Because the personnel who were below me, junior, my lord, they have already received the promotion of assistant sub-inspector, whereas I am still
Now,
head constable.
as per your submission, you should be in which rank?
Assistant sub-inspector, my lord.
What rank you holding now?
Head constable, my lord. Whereas my juniors are...
By seniority, you mean?
My lord.
As per regulation list, if you have prepared...
Yes, my lord.
Taking notional seniority from 25/4/2012. Okay. That's it.
That's it, my lord. I don't know what my friend will say.
Yes, this judgment, why is not complied with? I mean, in letter and in spirit also? In letter and spirit?
Well, that has been complied with, my lord. Now the question
No,
is...
but the question is now, where, now let's see your, sorry, we're not looked into your petition at all. Why you want to effect 1/4/2017? The others were promoted at that point of time. Who is said junior to you?
Well, here what happened, my lord? The facts is slightly different, my lord, what my friend has submitted. Initially, he was enrolled as constable in 2001, my lord.
2001, 2011.
1912, 2001, my lord.
Okay.
Thereafter, my lord, he applied for the post of head constable, my lord, against an advertisement that was issued in 2011, my lord. So this was a fresh recruitment, my lord, to the higher post.
Of course, if you make technical resignation, that means it's a fresh recruitment. That implies itself. Yes.
So, my lord, he resigned from his constable's post and joined this post, my lord.
But he's not allowed to join.
Now, my lord, because he was diagnosed with HIV, my lord, so his appointment was kept under suspension, my lord. He came before this honorable court and was directed to be appointed. We appointed him, my lord. Then secondly, because there was an intervening period of about 2 years, 12 and 14, my lord. Actually, he joined in the month of August. 14/8/2014 is the actual date of appointment. And the monetary benefit from the date of actual joining, seniority notionally from the date of his selection, my lord, from 2012. Now he becomes due for next promotion, my lord. Now
That's been given. Notional seniority has been given.
That has been
from
given,
2012.
He has been given pay and allowances from the date of joining, so there is no problem.
Date of joining, my lord.
They joined 14. They joined 14. But notional seniority from 25th of
2012, my lord.
Okay, 2012.
Now what happens, my lord? Because of his HIV, he has been placed under low medical category again. And the rules require that for promotion, because his next promotion will be assistant sub-inspector, my lord.
ESI.
ESI. So for that, he has to be in SAPE 1, my lord. He was not in SAPE 1, and that is the reason he has been denied the further promotion to ASI, my lord. Against that, he has come to the lordship. His denial is not on the ground of seniority, my lord.
Only because of health.
Because of his health.
Yes, Mr. Guru. Is he in shape 1?
My lord, what has happened, my lord, at the time of my promotion to my lord as head constable, my lord, from constable to head constable, my lord, I was in shape 1, my lord. Just because for the fact that I have contracted, my lord, HIV, my lord.
Now your notional seniority has been restored. Now the question for them not promoting you now is because you're in low medical category, and so...
My lord, I'm coming to that, my lord. In the year 2012, my lord, I was in shape 1, my lord. I was constable. Thereafter, I qualified for head constable, my lord. At that time also, I was in shape 1, my lord. That certificate was given to me. Just because it was found that, my lord, I have been HIV positive, my lord, I was just randomly put as shape 2, my lord. Because, my lord, a person contracting HIV can perform, my lord, his duties in shape 1, my lord.
Well, there's no
in
problem
shape
with
1,
that.
my lord.
But only one question now. When the question of promotion came, that is which year? You're asking from 2017, correct? For correction. For yes, I promoted from 2017.
Yes, sir, my lord.
If I just saw it somewhere. Anyway,
1417.
now in 17, what was your medical condition? Shape 1 or shape 2?
Shape 2. I was placed in shape 2, my lord.
Then?
But the reason, my lord, is only for HIV, my lord. It's not for some other purpose, my lord, which I was at...
See, we're not experts to discern whether a person having HIV at that relevant point of time, HIV is not, will not disable you.
My
Will
lord.
not like make you ineligible.
My lord.
But health considerations, if you are a discipline force, they have to consider it on other parameters, not a question you have HIV. You can have any disease.
My lord.
Correct?
My lord, before answering that, my lord will please come to page, Annex 1, page 25, my lord. Of my writ petition, my lord.
Yes.
My lord, here I am placed at, my lord, serial number as per seniority, my lord, 1922.
Okay.
Now kindly come to, my lord, next page, that is 26. My junior, Mr. Amit Prasad, is at 1953.
Okay.
My lord. Subsequent to which, my lord, that judgment and order was passed in 2014 to calculate my seniority from, my lord, 2012, my lord. Now, my lord, if it was complied, my lord, kindly see to come to page 27, my lord.
Yes.
Effective will be, my lord, page 29, my lord. My junior is placed at, my lord, 954. My lord, got it?
Yes.
And, my lord, I am placed at, my lord, page 35, my lord. Kindly come to one. It is serial number 1415, my lord.
How do we?
My lord, at this point of time, my lord, my medical category was not even fixed, my lord. So it only points to the fact that, my lord, by dragging the department before this honorable court, my lord, I have attracted the wrath of the department, my lord. Nothing else. See, my lord, this is apparently in compliance of the judgment and order dated of 2014, my lord. Nothing to do with 2017, my lord. Here also I have been placed, my lord, far below my junior, my lord. Let this be rectified, my lord, then we'll come to the next phase, that is 2017, my lord, about my low category, my lord.
This is dated when is the gradation list?
Yes, my lord.
This is what? Seniority list of head constables.
It is of 2016, my lord. At the bottom, my lord, you will find, lordship will find it.
Okay, 1st November 2016.
1st November 2016. How can my friend come to 2017, my lord? The judgment and order of 2000.
No, but only one person.
Only one person. No. There are plenty, my lord. This is only.
No, how maybe that person's been corrected on his gradation is corrected on maybe he has some other.
No, my
issue,
lord.
Some litigation. How
No,
do you know?
no, my lord. My lord. That can be, my lord. It can be recorded. My submission can be recorded, my lord.
Recording submission will not serve any purpose.
My lord,
only thing you have to show, you have to substantiate your.
My lord, this is one, my lord. There are plenty more, my lord. Apparently, my lord, once, my lord, I have been superseded more than 1,000, my lord, by 1,000 serial number, my lord. There must be some more, my lord. This is just as an instance, my lord. This is apparently in compliance of the judgment and order of 2014, my lord.
And after 18 judgment?
My lord, 18, my lord.
After the 18 judgment regarding
I am still there, stagnant there, my lord. And now my...
But your the date of entry into service is taken as 2012.
No, 2014, my lord.
No, that is only for monetary benefits. 2012 has constable taken.
My lord, had my seniority be calculated from 2014, I would have been in top of this.
No,
on top of this, my lord.
Order. It says. See, upon petitioner shall reckon for the purpose, last line, seniority and other benefits, notionally from 25/4/2012, monetarily 14/8 from the date actually.
My lord.
Fine. Now, you mean to say that we'll take as a baseline, right? 25,012. Now you say the other people who were
junior to me, my lord.
Junior to you, from this date of your notional seniority, have superseded you.
My lord.
And they're saying that it's because of your shift to category.
That is up to 2017, my lord. This upgradation is up to 2016, my lord.
No, but will your medical condition affect your gradation list?
My lord, subsequently, 2017 onward, my lord, I have no issues there, my lord. I might come with some more plea, my lord. But this gradation is of 2016, my lord, and that is in compliance with the judgment and order of 2014, my lord. 2017 is not in the, my lord, picture as of now, my lord. Kindly see, my lord, the Annexo 1 is of, this is of 2012, my lord. Gradation list is of 2012, my lord. Kindly see. Annexo 1, my lord. Page 26, at the bottom, my lord. This is of 18th October 2012, my lord. Whereas Mr. Amit Kumar is far below me, my lord.
No, but that time he hadn't come to court 2012.
Already, my lord. Oh, at that time, my lord, I was not there, my lord.
Then?
So my seniority was...
So you mean to say this is a correct position?
My lord, yes.
How?
Because my lord, page 26, serial number 1953, my lord, Amit Prasad, is below me, my lord. Now, in compliance of judgment and order of 2014, he has been placed far ahead of me, my lord.
My lord, it appears that the submission of my friend is not correct, my lord. My lord, the revision of
Annexo 1 is, what is this? I mean, there's no heading to this Annexo 1. What is it?
My lord, this is the gradation list of 18th October 2012.
Where does it say?
Is at the bottom of the page 26, my lord.
It does not say the gradation list.
My lord, it's just a one page of the entire list, my lord.
My lord, that
it's
is
a bulk, very bulky.
Kindly see page 36 of my affidavit, my lord. Pursuant to the order of Justice Mead, my lord. First, Lordship, kindly see page 32, my lord, of this affidavit.
Oh, yeah, affidavit.
My affidavit. Page 32 is the order, my lord, by this honorable court, 26/7/2018.
Yes.
For a direction to refix the seniority, my lord. And pursuant to that, my lord, page 36.
Yes.
My lordship, the relevant part, para 11 at page 38, my lord.
Yes.
It reads, my lord, now therefore, as approved by the worthy DG BSF, seniority in rank of head constable ministerial in respect of number so-and-so Solomon Longkong of 93 BNBS hereby refixed as central seniority number 511A instead of central seniority number 987 between number so-and-so Nagaraj so-and-so and Dharmraj so-and-so so-and-so. So, my lord, his seniority has been refixed, my lord. He has been upgraded by 400 ranks, my lord. So in my humble submission, seniority is not a problem, my lord. Seniority is not an issue, and that is what we have stated in our affidavit.
Now just see the, yes, just see it again. Now therefore prove Ministry so.
Yes, my lord.
Is hereby refixed the central seniority number
Yes.
500A
Yes.
instead of
Central
987
seniority.
between
Yes.
Nagarajan and
Yes. A number is given, my lord, because
Yes.
it will be widely stated.
Where is this recorrected central seniority list?
complete list has not been annexed, my lord.
Where's the list to show him vis-a-vis that he's having a grouse with?
In that case, my lord, let me be allowed to, or my friend can produce the, my lord, entire list, my lord, which is not in my possession, my lord.
No, see, the case they're setting up is that seniority list is not an issue at all. It's only a health conditions issue. Which
No.
Not given. No, that's what the case. I'm not saying. I'm not arguing with you, Mr. Gurung.
I'm sorry.
Just putting to you the. You feel to understand that's his case. He said, forget the seniority. It's a question of your health.
I'm sorry, my lord.
Yes.
My lord, I have made a categorical submission at paragraph 18 of my writ petition, my lord. If I may read, my lord. Page 19, my lord.
1 second. I have not gone through the file. So anyway,
then in that case, my lord, let
I'm
it.
just listening to your submission. That's what I'm looking as we go along.
In para 20,
Now, where's the final answer to all his representations?
Para 20 and 21 of my affidavit, we have stated clearly, my lord, why he has been denied promotion.
That is medical, my lord.
That is medical.
What? No, where's the order that reflects that? 2021?
Para 20 and 21, my lord.
Is it a permanent low medical category?
No, my lord, it cannot be.
Para 21, we have said, my lord. At page 13, you also kindly sees from the first line only, my lord. DPC held on 19/1/22, but he was adjudged as unfit for promotion due to his permanent low medical category. That is, say one medical category is essential for promotion of the next higher rank, due to which he was found unfit for promotion of the rank of ASI. The reply to so and so on the second representative was accordingly informed to the petitioner by its letter number so and so dated 76/2022. That letter is at page 81, the last page.
Yes. So, Mr. Gurung, what to do? Can you show me any law which supports your case, authorities?
My lord,
to show that if you're even a permanent, permanent low level, whether you're entitled to any kind of review.
My lord is very correct, my lord. If need arises, my lord, I'll do that. But however, at this juncture, my lord, kindly appreciate, my lord, that I have been placed in low medical category as per my learned friend in the year 2017, my lord. Whereas my seniority should have been fixed, my lord.
We're not talking about seniority at all now.
My lord, there is, my lord.
We're not talking about seniority. We will examine that, but show some authority.
Then in that case,
it is squarely, you see, you read this page 81?
My lord, I have read, my lord.
You read it out loud.
My lord, yes.
Para 3 only.
Para 3. Further, it is to intimate that your name was considered by the DPC held on 19/1/2022, but adjudged as unfit for promotion due to your permanent low medical category shape 2, my lord. The DPC, after taking into consideration the provisions contained in BSF Combatized Ministerial Cadre Group A, Group B, and Group C, Recruitment Rules 2011, the Shape 1 medical category is essential for promotion to the next higher rank, but found you unfit for promotion to the rank of ASI Ministerial. The instruction
What is the instructions contain healthcare system?
My lord?
What are these instructions contain healthcare system? Is it anywhere in the materials here?
That's what
It's not the next one. I can place it when the matter comes tomorrow.
Because in case of illness is permanent nature, now what are the considerations?
He can't do promotion.
Now whether that means he's deprived of all his promotional benefits.
Till he regains his shape 1, my lord.
No, but you see,
but if somebody is permanent, that he
what's the
he
question
has
of
to remain in
regaining?
that post, my lord.
But then there's no
But he only get ACP and MSCP, my lord. But
of course, but then there's no
promotion
possibility of review medical board and review DPC. No.
There is, my lord. There is, my lord.
Show the law, Mr.
Well,
Guru.
let it come after a week, my lord. At the same time, my lord, the authorities also I'll place before your lordship.
If we authorities, so should we understood your case now?
My lord.
The question was, they upgraded you as per the court's order, but they said fine when it came to consultation, forget the period 17 to 19. Forget about that period. Everything can be corrected if you can show that you know, at that
lord is
time 22 you are in shape 1. That's only
absolutely, my lord.
Matters heard at length. Counsel petitioner please without some time to produce further materials including authorities in support of this case. Published after 1 week.
2 weeks, my lord. 2 weeks.
Then the whole forget the whole matter.
1 week, my lord, in that case.
30.
Lordship.
Yes, Mr. Pandey.
This is a matter, Lordship, where the petitioner, while undergoing training in the Assam Rifles, had suffered disability. And his disability was assessed to be at 40%, attributable to service. And he was boarded out, Lordship. And at the time of boarding out, he was told that he will be receiving his disability pension. But he kept on waiting, Lordship, but he did not receive any pension, disability pension, Lordship. Finally, Lordship, in my writ petition, Lordship.
Well, this is taken up tomorrow day after. I could go through his file. I couldn't go through his file. Tomorrow day after.
Too many matters on your board, on your plate also. Not tomorrow, so next week. At the request of LTHA, I did personal study this matter after 1 week. So now there are other judgments regarding permanent disability.
There are, Lordship. The Meghalaya High Court Division Bench judgment also is done, Lordship. Here I am having the disability percentage of 40%, Lordship. In that case, 20% disability was also granted disability pension, Lordship. The sole ground of the respondent is that because my disability is below 60%, that's hence I will not be, I am not permissible for disability.
If it's
Lordship.
No, there are other high courts also. I think
that
40%.
Amended also.
No, the 40% also is been amended recently. 40% should 40% is substantial.
Lordship.
Yes.
Highly obliged, Lordship.
33.
It matters. Apa ya taruh?
Lord, I'm entering appearance on behalf of number 4, my lord, today. I'll be filing my...
Never appeared before.
No, my lord.
Who's number 4?
On the last occasion, Lord,
first time they
noticed that MIDC as well as 2 private parties were being represented by the same council, and objection in this regard was raised by the petitioner as well.
Then we won't allow you to appear then. In the joint written object to same, for instance, that action have been made against 4 and 5.
No, the MIDC is being represented by...
By you?
No, my lord. I'm also entering appearance.
AHE.
Madam sharing, madam sharing with
You have And you are appearing for?
I'm entering appearance today, my lord,
On behalf
for,
of whom?
respondent number 5, the retired MIT managing director.
Oh, there was a mix-up before.
Yes. Yes.
Because even 4, you are number 4.
Yes.
I mean, number 3 is MITC.
Yes.
The present. Yes.
Madam Sharing was
She
appearing
appeared for all of them.
All
even
of
for the-
them.
I mean, right. And you're appearing for the state.
1 and 2 for the state.
Right. So you're appearing for 3 MIDC. Now you're appearing for 4.
And
who's 4?
Director.
The present
Newly
managing
appointed
And you have
director.
to draw the affidavit. Well, have you drawn the earlier affidavit? Then how can you file another affidavit in the course of the day?
Lordship,
Without leave
the
of
last
court?
occasion, they prayed for withdrawing. But Lordship passed an order, last order, Lordship, can you see? So they are allowed to file the additional
supplementary
affidavit.
affidavit.
Yes.
Right, okay, yes. You haven't filed it now also?
It's ready, Your Lordship. We just got it notarized.
Yes, take down. Sole happened to rejoin the objecting to 4 and 5, we reserve by 3. Are you prepared to waive that or make that a point in issue?
That should stand
No,
waived.
that's Mr. Charesu's
I hope that if it will be confined to the low point, which may not be necessary for me to file a rejoinder.
Okay, yes. In consideration to the observation that, or in consideration to the fact that a joint affidavit has been filed on behalf of respondents number 3, 4, and 5. Stop. By order dated 2/4/2024, MST Yangi Leonard Senior Counsel, by so and so for respondent number 3, prayed that respondent number 3 itself be allowed to file a supplementary affidavit and disregard the earlier affidavit. You want to recall the earlier affidavit?
Yes, that may be disregarded.
And that the sorry.
It's along the same lines, Your Lordship.
Oh. To affidavit, today she submits that the said affidavit is in the course of being filed. Additional prayer has been made that the earlier affidavit, which has been filed jointly for 3, 4, and 5, and advertently be allowed to be recalled. The prayer is allowed. Next paragraph, Mr. Kibi Bharatchaji has entered appearance today on behalf of respondent number 4 and MS Bang on behalf of respondent number 5. They pray for and allowed?
My Lord, may we pray for 3 weeks?
Time to file.
3 weeks time.
3 weeks time to put as one affidavit. 3 weeks time to file affidavit. Yes. It's the matter after 3 weeks. In the order column.
34.
But very unfortunate that the petitioner passed away last evening. So, he was in the ICU for quite some time. So he passed away last
Pension
evening.
matter?
My Lord, this is regarding pay, my Lord. Areas of pay regarding graduate pay. So,
He's a lecturer?
No, my Lord, he was a teacher, my Lord, aided school. Teacher. Government school.
You're still in
Government
service, he died?
My Lord?
He's still in service?
No, my Lord, he retired from service.
He'll be substituted then if they are.
Yes.
Yes, Mr. Nobody submits that the petitioner has expired on, that's that yesterday is
21st.
21 4 2024. So if this was allowed to bring in a substitution applicant substitution.
4 weeks. 4 weeks.
This matter of 4 weeks there.
35.
Yes.
I'm praying for some accommodation in this matter. I was just informed that Ms. NG Shalash is indisposed.
Today is for disposal.
No, your Lordship has already heard it. That was the only matter, where the central government was to issue the clarifications on the basis of the letters issued by the Director of Industries,
Only one thing, Dr. Saraf, the asking for accommodation as the senior government advocate is unwell. They have to after 1 week, yes. As stated that senior government is unwell, this matter after 1 week, yes.
I'm obliged.
Yes.
36.
But this matter is for notional promotion, my lord.
For?
Notional promotion, my lord. He's since retired. This is for the post of director, DMR, my lord. Directorate of Mineral Resources, my lord.
Well, it'll have a, from which year?
My lord, DPC sat in 2000.
Are you ready?
We can have it some other day.
Some other day, Your Lordship. No. Otherwise, it's a short matter. It's not really long.
It'll take some time to place the facts. Lordships can have it sometime next week, Lord. On joint request.
Constantly the matter be taken up, jointly request the matter be up to 1 week. This only so and so. Because the other matters there which we want to start.
That's 7.
May I please, Your Lordship? Lordship, this petition is filed seeking family pension of the deceased husband of the petitioner, Your Lordship. And in this case, Your Lordship, the petitioner is a widow of late.
He died in harness?
Yes, Your Lordship. After retirement, my lord.
After retirement.
Yes, after retirement. My lord, he has retired from service on 1/7/2013, Your Lordship.
2013?
1/7/2013 retired. After that, the chronology of events, Your Lordship, he died on 2/3/2021. 2/3/2021. Leaving behind the present petitioner, Your Lordship, the petitioner received a communication from the authority. Kindly see page, Your Lordship, 23, Annexure 2. Got it, Your Lordship?
Number?
Page 23, Annexure 2.
Yes.
She received the communication. May I read it, Your Lordship?
Yes.
To Omia Devi, wife of such and such, resident of subject, settlement of family pension in respect of late Bashanta Sharma, madam. With reference to subject cited above, I would like to inform you that this office has received intimation about the death of your husband, late Bashanta Sharma, who expired on 2/3/2021. In this regard, you are requested to appear in the office of the Chief Accounts Officer pension section, Shillong, along with your family members on any working day for settlement of the case. Your Lordship, when she went to the office, she came to know that family pension cannot be issued in her name alone, because the petitioner has nominated his son of his second wife in the nominee. And as such, Your Lordship, she filed in representation also before the concerned authority, but till now she has not received the pension. In this case, private respondent has been arraigned and they have received notice, and they have also filed their affidavit. My case is very simple. Being the first wife, I am entitled to pensionary benefits of my late husband. That is my simple case and pinpointed prayer in this regard. They have filed their counter also.
What did you say in the counter?
They say, my lord, their basic contention is that she is my biological sister.
Number 5?
Number 5, yes. Biological sister. And
that means you both
are sisters.
were wives of...
Yes, yes.
Okay.
So, and I have arranged the marriage, nothing to show on the record, but only vague statement has been made that I have arranged the marriage and I have accepted that marriage at that point of time. So,
no, that at least the son will be entitled. Son, how old?
Yes.
Son is aged at about 22 years.
Yes.
And he is entitled up to 25 years.
Yes.
That's all.
Yes, yes.
Yes, MS Kolni.
My lord, here the only issue is that pension was being released, my lord, to the private respondent.
To whom?
Private respondent.
You've been enjoying it?
No, my lord, that was our... The only thing is that as per the record, my lord, this petitioner's name was not there in the record, my lord.
No, not that. How will it be released to the private respondent?
No, so far as the record, my lord, that is what we have...
How? Have you filed affidavit?
No, my lord, we have not filed. Because, my lord, the pension of this late person, my lord, is still a dispute between the parties, my lord.
Right. I mean, have you filed affidavit?
No, my lord, we have not filed.
Why?
My lord, because until they don't decide who is the person who should be received, because as per the record, it is the private
respondent. Any
respondents.
affidavit to bring on record anything, whatever details you have.
Then that can
the
be
thing is
brought,
that if the
as
thing
per
is
our
that if the
record.
dispute between the petitioner
And the private
respondent
respondent.
4 and 5,
My lord.
now forget the second wife, the marriage will not be recognized,
My lord.
even whatever, but the son will be
The
entitled to some. So the thing is that they can split it, the family pension between the son and the
My lord, if
and
it's
the
so, my
first
lord,
wife.
in the previous case also they have split, my lord, in one of the cases. In that case, the corporate should not have any problem, my lord.
Where's the order?
My lord, just recently on the last occasion, my lord, last week also we disposed one matter, my lord.
Disposed?
My lord, yes. In which both the parties had decided 50% of the pension, my lord. There were two wives also in that same case.
Where's the order where they refuse your pension and
No,
saying
there is
that?
no refusal, my lord.
No refusal.
There's
You
no
know where they've
refusal.
said that there's other claimants?
He said so, my nominee, my lord, in terms of nominee. in the
Yeah, where's that
report.
nominee?
Page 23. Page 23, Annex 2 of my petition.
No, fine, but nominee, where it says
Nothing is on record.
No.
Lordship. So,
record will be required. Record will be required. How will you dispose like that?
Or otherwise, my lord, kindly allow me to file a short affidavit, my lord, after going through the
Within 1 week you file
My
it.
lord. My lord, 1 week will be difficult because
The
our
matter
officer in
suspension, you
charge
can't
is
deprive four
on
widows.
leave, my lord, on medical leave. Mr. Dakhari is on medical
Who
leave.
is Dakhar?
The law officer who helps us with all the court matters, my lord. 2 weeks, my lord. Probably he'll be joining within 2 weeks.
Yes, in the course of hearing, it is noticed that an affidavit is necessary from the respondent corporation number 123, as much as and to substantiate as who is the nominee in the service records of the deceased employee, for which this employee stopped. What's the name? This employee?
Bashanta Sharma.
Bashanta Sharma.
Stop MS only. Praises we will have 2 weeks time to file.
My lord.
To provide this information. Even what affidavit, just instructions.
Instruction, my lord.
Yes. Just after 2 weeks.
For hearing itself, man.
We'll dispose of next day.
Yes.
I'll come out with instruction, my lord.
All right.
38.
And also that whether pension has been given to someone. That also.
May it please, Your Lordship.
Yes. Finally.
Item 38 to 43 are connected, my lord, and there was one matter in
That order matter of Mr.
Ms. Sanchita Ain was appearing in the matter.
18. Item 18.
Yes. Who start?
My lord, I am ready, my lord. Other parties, connected matters also there.
Sir, has the big matter.
No, it's now are we taking it district wise or we taking it
my lord, now it comes with different district also there, my lord. So
Well, at 43, the district council also has been made a party in 43. So
My lord, the issue is
addressing on
not
behalf
one.
of the-
Legal issue is common in all the matters, my lord. Legal issue is common in all these matters.
okay, we'll have it till 1:15, 1:30. Then we'll continue. Yes, because I don't think we can finish in one day.
Yes, it'll take some time.
Start. You're appearing in which one? So I just want I want to know who the councils are appearing where.
38, 38.
No, it's
The lead matter, my lord. Ayu Kumar.
lead matters,
Ayu
which
Kumar
one?
is the lead matter.
Lead matters, Mr. Chagreso.
My lord, Ayu Kumar.
Transfer number 2, 2019.
My,
Okay.
my lord, is a lead matter.
That's that TRP, that means number 2.
Yes, my lord.
Once the batch matters, when time comes to pass judgment, becomes very confusing.
Yes.
Yes. Yes.
My lord, I don't need to address the fact of the case, the legal issue.
Of course, you need to address the fact. No factual cases. No. What's the legal issue here?
The legal issue, my lords, we are seeking for transfer of the cases pending from the learned district session judge to the district council court in view of the conferment issued by the governor under para 5(1) of the 6th
This
schedule.
is East Kashil is one.
Well, East Kashils.
That's the unlimited district.
East Kashils. Well,
okay.
now, in the last occasion, with lordship permission, I have submitted a list of notifications issued by the governor.
These ones?
My lord.
That means the CRPC notification also?
But that also, apart from that, my lord, it started from 10 August 2011 notification.
Yes, yes, yes.
My lord. So with lordship permission, this is the first notification I relied on. This is the conferment issued by the governor, 2011, to officer of the district council.
Yes.
Confer on Sri Stilwell Karsimdi. Now, the next page, the next page, my lord, another notification, 17 March 2015. This also conferred to my lord Sri Martin, my lord, officer of the district council. And 2017, my lord, page number 4 of that compilation.
10 December 2015.
Well, 7
10 December?
Well, first is 10 December.
This one, what is this
Lordship,
one?
I may come back to 10 December later.
BMOV?
Madam, that is for Ripoy district. I may come later. Madam.
Okay.
May I come to the general notification, madam?
7.
Madam, 7 February 2017. This was referred to by the Honorable Apex Court also in the Solang Peo case.
Yes.
And my lord, page number 3, that is 10 December 2015.
Yes.
There was a conferment with regard to, my lord, one of the officer, Srimati P. Mauri, in charge district session judge for Ripoy district.
Conferment?
Madam. Conferment upon, my lord, Sri P. Mauri. Now, nature of the, my lord, the notification, in exercise of the powers conferred under Rule 1A of the Rules for Administrative Justice and Police in the cases and such, and further under subparagraph such, my lord, as adapted and amended by Meghalaya, read with paragraph 5 of the 6th Scheduled Constitution, the Governor of Meghalaya, with the approval of the Honorable High Court of Meghalaya, is pleased to appoint such in charge district session judge Ripoy as the additional Deputy Commissioner Ripoy district for the trial of all offences punishable with death, imprisonment for life, imprisonment for a term of not less than 5 years under the Indian Penal Code or under any other law for the time being applicable to the district, and also to hear all civil and criminal revision appeals, etc., from decision of the assistant to the Deputy Commissioner within the said district. And the Governor is further pleased to direct that such district session judge as additional Deputy Commissioner shall, for the purpose of said, exercise all judicial powers of the Deputy Commissioner within this said district. This supersedes all earlier notification issued under the opposite provision within Ripoy district. So this is the notification in 2015. Now, Yo Kumar case, my lord, here, we have filed this transfer petition.
Kumar?
My lord, the present petitioner is the Yo Kumar. Now, he has filed this transfer case before this court in 2019. Now, during the pendency of that 2019 matter, the Kumarjan case was also filed before the division bench in 2020. And, my lord, the argument was proceeded with regard to Kumarjan matter, and the respondent state relied on this 2015 notification, as well as the notification, my lord, page number 5. Page number 5 of the same compilation.
This is 03
Well,
2018.
well,
What does it say?
my lord, 3rd May 2018,
Yes.
my lord. Now, in exercise of the, my lord, power conferred under such and such, 1950, 37, and further section 1 of 2 of the such and such, adapted and amended by the Meghalaya, read with the paragraph 5 of the 6th Schedule Constitution, is pleased to confer on the district and session judge. Now, early 2015 is appointed on person, Shrimati P. Mauri. Now, here confirming is district and session judge.
By office, not by
By
person.
office. By office. My lord, so in the Kumarjan case, they relied on these notifications. So there was a hearing, but we advanced our argument also. Then the judgment was delivered that the district and session judge in Nongpo has the power to take up the trial and pass a sentence. So there was no illegality. So that was the judgment in the Kumarjan case. Now, I have seen the affidavit given by the respondent today in my case. Now, they have annexed similar, my lord, to 3rd May 2018, similar notification issued for the East Khasi Hills.
Okay.
East Khasi. May I show that? Well, the affidavit, my lord,
This is going to suffice for all, Mr. RK General. Is it going to suffice for all the cases?
Yes, my lord. Yes, my lord. The legal issue is common, my lord.
One affidavit only.
One affidavit is because either the issue, my lord, if I may submit, my lord, issue is whether the district and session judge
Exercises.
acting as additional DC has the jurisdiction to try the cases where the offence is punishable with sentence of more than 5 years. Because your lordship is aware that para 4 confers power on district council to try the cases where the sentence is less than 5 years, my lord. And para 5 of the constitution says that by confirming notification, my lord, the jurisdiction can be conferred on district council, my lord.
No, of course, no quarrel with that.
This is the, so my lord, and in all these cases, the petitioners who are seeking transfer of trial are facing trial where the sentence is more than 5 years, my lord. If I can place the constitutional provision, my lord, paragraph 4 and 5, my lord. The issue will get crystallized, my lord, and in that light, your lordship will see the notifications.
with regard to sentence, there is no dispute. The only, my lord, the stand taken by the respondent is the judgment delivered by the
My stand
is binding.
My lord, I have not yet argued my case. I have not yet argued my case.
Yes.
Your lordship will see paragraph 4, my lord. Administration of justice in autonomous district and autonomous region. The regional council for autonomous region in respect of areas within such region and district council for autonomous district in respect of areas within district other than those which are under the authority of regional council, if any, within district may constitute village council or court for trial of suits and cases between parties, all of whom belong to scheduled tribe within areas other than suits and cases in which provisions of subparagraph 1 or paragraph 5 of schedule apply. So if paragraph 5 subparagraph 1 applies, it will be the jurisdiction of district council court will be ousted, my lord. Now kindly see paragraph 5, my lord.
Yes.
Now paragraph 5, your lordship will notice that the government may, for trial of suits or cases arising out of any law in force in any autonomous district or region being region being a law specified in that behalf by governor, or for trial of offences punishable with death, transportation of life, or imprisonment for a term not less than 5 years under Indian Penal Code or any other law for time being applicable to such district or region, confer on district council or regional council having authority over such district or region, constituted by such district or any other officer appointed in that behalf by governor, such power of code of civil procedure, or as the case may be code of criminal procedure, as he deems appropriate, and thereupon said council court or officer shall try dispute or cases offences and exercise of power so conferred. So only by virtue of notification, my lord, under section 5, district council court may have the jurisdiction to try the cases where sentence is more than 5 years. In absence of any notification, district council court will have no jurisdiction, my lord.
But then the notification is there for the east for.
So now your lordship.
My lord,
No, I will answer. I will answer the
whether you know like now only one thing that's in the mind of this court is that the notification was issued in 2022, making the CRPC applicable to
applicable.
But again, there has a rider that the powers of district council under 4 and 5 remain untouched.
Yes. I will place that part.
Says that if within tribal should go there, and if been vested the power under para 5 by the as done in the case of this conferment, that means that they will exercise concurrent jurisdiction, or are you saying that it can sorry?
No, maybe if I
should go to district council courts. Yes.
No, Milord, para 4 are the cases where the sentence is up to 5 years. So those cases have to be tried by district council court. There is no dispute about it.
Power is there for district council judge to try matters transportation for life.
So now your lordship, so therefore, my lord, the question which falls for your lordship consideration
by persona designata is done on a certain judicial officer.
No, I'll try to answer that. I will answer it also, my lord. Now if I summarize my argument.
Just hear the court.
No, my lord.
There's no,
yes, my lord. Sorry.
Quarrel with Jayante Hills because there's been no conferment on any judicial officer in Jayante Hills. So all the cases go to the regular courts. But in cases where there has been conferment of power upon the district council court, a judge, to try like offences over 7 years, transportation for life, imprisonment, even death sentence, I think. So then, how do we reconcile
I'll
that?
answer, Miller.
How do we reconcile that? Do
I will
reconcile
answer.
it?
I will answer.
Okay, then let Mr. Chandra.
May I answer? May I answer this, my lord? Yeah, because that will crystallize the issue, my lord.
Yes.
Now, your lordship is aware that under the Scheduled District Act, the ADC, Additional Deputy Commissioners, have been conferred power to try the cases where the sentence is more than 5 years. That conferment is upheld up to Supreme Court, my lord, in Ratan Singh case. In Constitution Bench has held that they have the power to try the cases.
Yes.
Now and there are notifications conferring power on Additional Deputy Commissioner, my lord,
yes, to
try the cases. This is one power which they have. Now petitioners are seeking transfer of the cases from ADC's court to district council court.
Yes.
On the ground that there is a conferment of power on district council courts.
Right.
The power has also been conferred on ADC, my lord, Additional District Session Court. So they are also competent to try the cases, my lord.
Right.
And so therefore they have the power to try the cases. There is no dispute about this.
Okay. Yes.
So to that extent, now, so if they have the power, my lord, your lordship may not go to the issue whether they have the concurrent power or not. They have to show that the issue which falls for lordship consideration is whether Additional District Deputy Commissioner is devoid of power to try the cases or not.
Not devoid of power. It's not the power, it's a jurisdiction. Now confirmed by paragraph 4.
So with the additional district. So if I rephrase, sorry.
Yes, take Richard Lingdo case.
I'm sorry.
Now, if IR is filed by any person, but then it involves an offence against a tribal person, which can be termed a tribal, then necessarily it should go to the district council.
Your lordship. Under the Scheduled District Act, all cases in the scheduled areas were to be tried by Additional Deputy Commissioner, my lord.
That's before
by
the
virtue of schedule.
Now we are bound by the Constitution.
No,
right?
my lord. No, no. After the Constitution, also, my lord, this 1937, the administration of justice
You
rules
know
were
very
protected.
well, Ms. Kant, like, that what has happened is that Schedule 26 Act has been repealed, but as a special
Correct, Your Lordship.
measure, though the Act is repealed,
Yes,
the
Lord.
rules survive. Which
Yeah,
creates a very
yeah, rules
incongruous, but then
survive.
Ratan Singh has protected that. He said, fine, that is fine. Rules survive.
Yes.
Balance of
So
justice,
now the what is the ratio? What is the ratio falling from this, my lord? Under 1937 rules were applicable to the state of Meghalaya, my lord, or to all district council.
Correct.
By virtue of those rules, my lord, powers have been conferred on additional deputy commissioner to try the session cases, my lord.
How do you reconcile
Those powers have not been taken.
How do you reconcile
No,
it
I will
with
reconcile.
para four
I'm coming.
and
If I take now para 4, my lord, if your lordship will see, para 4 is only which is cases which are not covered by para 5.
Exactly.
So those para 4 are the cases, my lord, which are not covered by para 5. Para 5, my lord, are cases where governor may additionally give power to district council, my lord.
Which has been done. That is what. How do you reconcile this?
No, my lord.
Whether we're not no quarrel now with the with the power exercised by the district sessions judges. Okay, no quarrel.
Yes,
with
my
that.
lord.
But whether
Yes, my lord.
the conferment of power, by exercise para 5(1) by the governor.
Yes, your lordship. Kindly see. I'll just read it. Para 1.
That will denude the district council courts from trying these cases for which they've been conferred special.
No, my
powers.
lord. No, my lord, the issue is that if under para 5(1), the district council court will get jurisdiction only when the power is conferred on them.
Right.
They have no inherent right to try these session cases, my lord. Now the question is, so twofold question which falls for your lordship consideration is, if there is a conferment on additional deputy commissioner by virtue of 1937 rules, whether by conferring power on district council court, the powers conferred on additional deputy commissioner have been taken away.
Denuded.
Or jurisdiction has been taken.
It cuts both ways.
That is the first question.
Please, it cuts both ways.
Yes.
Now you see, denude the powers of district council court because of the investment of powers by by law.
So therefore, my lord, your lordship is aware that when you take away the power or in law, you have to do it by express language, my lord.
Yes.
If there is no express provision taking away the power of additional deputy commissioner to try the session cases, my lord, then also the additional deputy commissioner is entitled to try those cases.
No quarrel with that.
The
but
case of the petitioner. So the case.
See,
I'm coming.
Situation. If there were no conferment of powers, no paragraph 5 situation, no quarrel. No quarrel. I mean, it's.
My lord, I take it, my lord. I in both ways. I'll approach the whole issue in both ways. Whether conferment is there or not. Second, whether by conferring also, whether the power jurisdiction of the regular district and session court has been taken away or not. Both manner. Both ways. I'm trying to approach the issue, my lord, from both ways.
Let us just frame the terms of reference. So because it's a deciding point of law only. Like
This is one.
It'll be helpful if you
I will draft the.
You draft terms of reference. Also, Mr. Changre. So
Yes.
it's like substantial question of law only. We'll decide within those parameters. Because understanding the court is that we have to not only the historical perspective, but the how would interplay between the para 4, 5 and Amsterdam Justice 37 and the conferment what has happened, like which court be denuded of the powers, like where it weighs more, that's all.
Perhaps the main problem, my lord, is that in Komarshan case, the case of Melvin Salangpiao was never taken to consideration.
I will deal with that Melvin judgment also, my lord.
The Supreme Court has held that in view of the powers conferred upon the district council, it is the district council which has the exclusive jurisdiction.
No, but then again.
No, Supreme Court has not held it. Supreme Court has not held it.
That is by.
My lord,
then came the notification applying the CRPC to the state. My lord is correctly. But now Section 1 of the CRPC also contemplates application of CRPC to areas. Now, your lordship will see the notification issued by the state. It's applicability to courts.
Yes.
not to the scheduled areas.
No, arbitral courts
That is a vast difference.
in the sense that you see, Mr. Dingdo, I think arbitral courts is that to have a, that you have a clear prediction or procedure.
Yes.
And also, but at the same time, they said that the powers of 4 and 5 is not taken away. This council
4 and
courts,
5 has been
but
saved.
But the CRPC is applicable, which is good in a way. So that's the thing. But you frame the terms of reference, just three terms of reference or 4.
And Milord, the second reference is, Milord, division bench has already considered all these issues and passed the judgment in Kumarchand, Milord. Now that division bench judgment is binding on all parties, parties including this court also, Milord. My humble submission, Milord. We'll frame the issue. We'll frame the issue in the light of whether
the court in coming to academic exercise whether it can be distinguished.
No, Milord. That is, we have to do it. That exercise has to be carried out, Milord. What I am trying to say that this will be one of the issue whether the issue is left. This will be left, Milord. So I will put my issues, Milord, on and my friend can also put the issues, and your lordship may have the frame common issue.
No, but then this court has ample power.
Yes. In the course of hearing, it is seen that as the question involve appealing questions of law, the senior counsel appearing in the matters both for the state and for the petitioners have accepted suggestions of the court to frame terms of reference on which the matter will be decided. Yes, we'll have it after.
After week.
1 week. Yes. Interesting. Yes. You can consult Mr. Hanzare also, since he's your senior. He's the general senior. Yes.
I bow down before your lordship. Lordship, I seek your indulgence towards item number 17, lordship. This is that matter to deposit money as regard to execution, lordship. Lordship, I humbly pray if the interim can be extended till the next date.
17?
Item 17 of the list, lordship.
And Milord, there was another transfer matter. That matter has to be tagged with this matter, item 18, if I'm not wrong.
Highly obliged, lordship.